I am still talking about racism or white institutionalism of the United States District Court, Columbia, South Carolina. This document before you is the motion to eject that was filed on March 30, 2015. In the prior video, I showed you a motion for an injunction that was filed on February 3rd, 2015 against the report and recommendation of Judge Page J. Gossett, where I lay out civil rights violations that should invoke the jurisdiction of the federal court. But just as I did on February 3rd, 2015, I did it here on March 30th, 2015, where I talked about irreparable character damage, deprivation, Title VII of the Civil Rights Act of 1964, defamation, serious character assassination, barred from applying, false charges of harassment claims. And so when I filed that injunction back on February 3rd, 2015, it should have held the report and recommendation by Judge Gossett in abeyance. And so therefore, I filed a motion to eject on March 30, 2015, laying out the civil rights claims that should have invoked the jurisdiction of the federal court. Now today we're talking about Judge Terry Wooten, who affirmed in his order the report and recommendation by Judge Page J. Gossett, even though it was unlawfully done. But what he did was so deceitful. He stated that I filed an untimely objection to the report on March 30, 2015. I did file it on March 30, 2015, but it was not untimely, and I'm going to show you why. And also in Judge Terry Wooten's order, he talked about document 29 and document 31. But according to the court records, there are no document 29 and document 31 unless there was action taken by the court that I was not aware of. And also, he talked about the injunction here. But he never really addressed the injunction. He just muted, and muted is a process the court used to deny someone due process without addressing their injunction or their motion. And the reason why he did that, because here again, I was laying out federal civil rights violation that should have invoked the jurisdiction of the federal court. And by not addressing the injunction or the motion to eject, he found a corrupt matter to deny me due process. This is the actual court docket sheet of the United States District Court regarding my complaint that I filed in December 2014 against South Carolina Department of Employment Workforce and others. As you see here, on February 3rd, the court recorded my preliminary injunction. They also recorded my objection to the report and recommendation. But as again, the court accepted my objection as timely because they asked for a reply on April 16, 2015. So when Judge Terry Wooten said that it was untimely, that was a willful distortion to deny me due process. But as again, this is what they do to confuse the record, to deny someone lawfully due process. This is the final sheet of the United States District Court docket sheet, which the report starts at number 19. That means all records regarding this complaint filed in December 2014 only had 19 recorded document numbers. So there is no such thing as 29 and 31 unless the court did something unlawfully and hid it on the bush to deny me due process of civil rights claims. To the United States Department of Justice, I have just provided you with additional evidence of judicial misconduct by the United States District Court, Columbia, South Carolina. I am requesting new investigation due to improper conduct or judicial misconduct. And to the state of South Carolina, you refuse to say my name. I said my own name. Justice is still required.